G.S. Bajpai and Mr. Michael Peil. This Legit class is organized by Legit Quest, which is an artificial intelligence-based legal research product. Legit Quest recently has also started with Legit I, which has news, interviews, and columns. Today's Legit class is for learning on the future of legal education and the skills and expertise that students and academicians will need to adapt in an altered landscape that we are facing today. I am Anushka Bhardwaj Aurora, and I take this opportunity on behalf of Mr. Karan Kalia, who is the CEO and founder of Legit Quest, to introduce our esteemed guests today. Before that, the esteemed guests would be talking about the said topic for 20 minutes each, and thereafter the last 15 minutes would be reserved for questions that we would be taking up based on the questions that we've received or the questions that we receive in our chat boxes. Our first speaker for today is Professor Dr. G.S. Bajpai, and we are honored to have him here. Professor Dr. G.S. Bajpai, good evening once again.
Good evening.
Professor Dr. G.S. Bajpai is the Registrar and Professor of National Law University, Delhi. He has held several prestigious international assignments for advanced research in criminology, criminal law, and criminal justice system. He is also credited to have led the initiative of digitalization of legal education in India by developing over 1,000 modules of e-PG pathshala and massive open online courses, which are the MOOCs, under the aegis of UGC and MHRD Government of India. Our second speaker would be Mr. Michael Peil, and we are also honored to have him today evening. Michael Peil, welcome. Mr. Michael Peil is the White and Case Vice Dean and an Associate Professor at the JSW School of Law, which is the first and only law school in the Kingdom of Bhutan. He earned his Juris Doctor from Cornell Law School, USA, and his bachelor's degree from Wake Forest University, also in USA. He presently chairs the committee that is responsible for determining the online contingency plans for the 2020-2021 Philip C. Jessup International Law Moot Court Competition, which is the largest moot court competition for law students in the world. And having said this, once again, I'd like to remind all the participants that have joined us today that we have a 45-minute session from now on, and we will be taking up questions that you can send us in the chat screen as well, into the chat that you can see. And before I give the lead to our distinguished panelists today, I would again request all our participants to mute the entire session today evening. So having said this, I would like to give the lead to Professor Bajpai.
Well, thank you, Anushka. Very good evening to all. Especially, I acknowledge my sincere thanks to Mr. Karan, who is my good friend and regular visitor to us, and also Mr. Rohit and Anushka, of course, part of the team, and my fellow panelist, Mr. Michael, and others, teachers, students, and others who are joining here. A big hello from my side. Friends, this discussion is slated on a very topical subject where we are supposed to look at the future of legal education from the viewpoint of his skills and expertise that the students and academicians would need in an altered landscape. Now, for me, this altered landscape connotation is extremely significant because the India is a very different type of landscape where we look at the legal education being very, very complex and massive. To give you an idea about the Indian legal space, may I say that we have over 1,500 law colleges and law schools where some 1.5 lakhs students graduate every year. Now, this is the size why I'm describing this, because any innovation that you wish to have in the arena of legal education, you need to think a lot about the access, about its portability, about its dissemination. Now, dissemination is a huge issue. In India, typically the regulation of legal education, undergraduate legal education is carried out by the Bar Council of India, and the postgraduate legal education is regulated by the University Grants Commission. Now, what are the critical concern at this stage when we are passing through a very disturbed time, when a corona outbreak is threatening us and testing us, I would say, in many ways. I'm reminded of Albert Einstein, which is very apt at this stage to quote him: in the middle of difficulty lies opportunity. And I have seen the law school experimenting in a full swing about their online and digital capacities in these difficult times, in terms of organizing the courses and also in terms of experimenting with the pedagogy that the law school have been adopting. I also quote Mr. Felix Frankfurter. He said the law is what the lawyers are, and the law and the lawyers are what the law school make them. Now, what law school are going to do in a challenging time, that is something very, very important. Now, a brief picture about how the law schools have been generally doing in India, and what are their major concern, I would say, and what are their major methodologies. Now, I would say, in terms of my focus in today's talk is on two issues. One is, are we techno ready in terms of extending the best possible solutions to legal education from the viewpoint of digitalization of education and otherwise. So what are the challenge in that case? I have seen the development, especially after the outbreak of pandemic. I found there are three types of institutions. So in the first categories are those institutions which responded this crisis in terms of agility and reform mindset and ramped up their already existing system to serve the student. That was the first reaction. Second reaction or second categories of institutions were those who caught unaware by the situation and tried to address the issue somehow with free online tools. That is the second level of preparedness. Third, I found the institution which could not do much, and they lack somehow agility, resources, infrastructure to cater to the requirement of legal education in this particular time. Now, why this is happening? Whereas India is supposed to be a country which is majorly represented by the youth population, more than 45% population is the youth population. We have more than 50 crores people using the smartphone, and digital technology is spreading like anything. I have only one concern, and the answer is very difficult to find. Somehow I make this statement in a very conscious way, that somehow the legal education has been very, very orthodox in terms of adapting the technology, the needed technology. And therefore you will find that the material aspect of development in any society move faster than the non-material aspect. I'm sure that those who are the students of sociology, they must have heard this theory of cultural lag, which aptly fits into the present situation when we are trying to innovate with legal technology and try to apply the legal technology in terms of education and all that. So we find the material developments always faster. So we are finding that the software, solution, computers, programs, these are coming very fast and they are available. But somehow the non-material aspects like human nature, like our mindset, it is not somehow moving that fast, and it creates a lag. It is called a cultural lag. And majority of the law schools in this country, I find, is struggling to cope up with this cultural lag. So on the one hand, there is a proliferation of the technology, but how, to what extent that technology is being put to use is something that is my concern. India, there is no dearth of techno solutions for different type of challenges the law schools are facing. But somehow that preparedness and readiness and that temperament and that mindset is somehow missing. And that becomes the first challenge that the people have to understand. I also find majorly there are 8 or 9 major aspects of a law school. So let us look at what is the law school, what is the configuration of law school, and how the things are influencing at this point of time all those parameters. So I am just mentioning there are 9 very important components of a law school. First is the leadership. I find the leadership becomes the sole factor as to how the law school is going to be. Now, in terms of adapting innovations, in terms of experimenting with technology, in terms of innovating with pedagogy, all these things become important if the leader is inspiring. So that becomes the first factor. I don't have time to elaborate on that, but I find that become a major hindrance as well as a major encouragement. Now, second is, like majority of the law schools are now at this point of time are struggling to solve their admission issues. Now, admission is something which is carried out in a very competitive manner in a majority of the law schools. And in finding the solution to this in the present situation is becoming very, very difficult. And how the technology is going to resolve this is very important. Currently, I also see the finance is becoming another crisis, especially in cases where the law schools are not fully funded or they are partially funded. So they have to sort of secure the enough funding to run the law school. Now, I find that those gone are those days when the sufficient and enough for full funding was available to these law schools. Now, why I'm discussing finance? Because finance compels one to innovate the things. So like in National Law University, we realize that the university has to sort of bring adequate funding if you have to sort of cope up with the challenges that you are going to have. So we have started organizing lots of online courses. We have started a very typical LLM professional program where executives are doing, and thereby not only you are contributing and expanding the reach of a national law school to the professional, but also you are earning a good support. So another aspect is very encouraging, and I think it is challenging too, that majority of the law teaching institution in India, because India is the biggest legal education setup in the world, with this kind of size doesn't exist elsewhere, with 25 national law university, more than 2,000 other law university, state universities and the central universities and colleges. Now the issue remains that what they are doing in terms of selling their courses or in terms of reaching out to the student. Now here comes the question of curriculum and pedagogy. Now, are we making our curriculum as per the demands of the market or as per the demand of the society? If it is not happening, then the law schools are bound to sort of getting into background. So some law schools have shown tremendous potential in terms of coming forward and adapting with requirements of the market, and they have started those courses. Now, another thing which is very typical to most law school, probably across the world, I would say, that is the pedagogy. Now, this is the least discussed topic, and I always consider that the transformation of law school as well as legal education, the key is always pedagogy. So we are recruiting the teachers who don't know really how to teach, and the kind of legal education that you are envisaging, and the kind of industry and academia link that you are trying to explore, that cannot be possible unless a teacher is able to deliver the subject in most effective way. Now, what are those effective ways? I realize that certain cutting edge subjects that the law schools have recently started teaching, like if suppose a course is on cryptocurrency or forensic science, or for that matter, AI, artificial intelligence, or for that matter, stock exchange or anything like that, you need to bring lot of lab work and practical simulation and lot of innovation in teaching strategies. Unfortunately, majority of the teachers are directly coming to the law school without having any background. Now that is affecting the quality of teaching, and in the end the performance of the graduates that are coming to the market. I think sooner or later, this point is going to be top of the agenda, that how the law schools are teaching. Because having a law school, having the student is not enough. That process has become fortunately very easy in this country because the course takers are many in this country. But somehow pedagogical innovations are not matching. Now, my next point would be the technology that we are talking and the other things that we are dealing with. I'm reminded of a very powerful spokesperson of technology. I'm sure many of you must have heard Richard Susskind. Richard Susskind is one person, is a British, who is dominating the scene in terms of bringing a host of solutions in the field of legal technology. And what he's saying is remarkable. I would really request the organizer sometime, let us devote a complete session on Richard Susskind and his work, because that is somehow gaining the currency at this point of time. I'll refer his work very briefly, and probably the challenges and the issues that we would like to mainstream would emerge from this discussion. I would refer his 4 prominent books, probably the most impressive writing at this point of time in 2020. His first book was Online Courts and the Future of Justice. Immensely brilliant work, and he is raising this issue because he has written all these books 5-6 years ago. It's not that after pandemic he is talking or discussing these things. He has indicated that this is the trend to be emerging, and are we really ready? And his second book is very interesting for those who are in the profession. It is Tomorrow's Lawyer. In Tomorrow's Lawyer, and the next book that he did was End of Lawyers. So Tomorrow's Lawyer and End of Lawyers, he is mentioning those techniques and innovations which are going to be, sea changing. And he calls a very nice, beautiful coinage he brought. He said there is going to be the emergence of disruptive technologies. Now, disruptive technology is the word, actually, the word, which is now becoming very, very important. And he's saying these disruptive technologies, which are AI enabled, are going to have serious implications to the lawyering, law firm functioning, law schools functioning in a major way. And he is also raising this issue that when he said end of lawyers, he said tomorrow's practice and law firm is not going to be the same. Probably the human demands in law firms is going to be significantly reduced because of the arrival of this technology. And interestingly, why he's calling the disruptive technology? Because he said there are 2 types of technology. One technology which sustains, orthodox, sustaining technology like we are using. This technology is sustaining the status quo of a law school, and we are somehow moving ahead without sort of bringing much innovations in what we are doing. Now, disruptive technology is a radical change in terms of really disrupting the existing system of working and rather bringing some pace and energy into our work. When I say pace and energy, which means we are ready to experiment with new technology. Now, AI-based solution he is talking 13 disruptive technologies which are going to be very, very important for law school. And therefore, he's talking, I am quoting him a very interesting sentence. So Suskind's idea of replacing uninspiring professors, or as he calls them, rumblers and dictators, by online lecturers would provide a student to be a part of lectures, speakers who deliver a memorable social and educational experience. So technology is not simply the commodity which is there to be consumed. it is going to be a very innovative response to our current problems. And if you find, when I was, Anushka was introducing about the EPG Pathshala and MOOCs, I'll give a very brief remark. When I was called by the Ministry of HRD to think of EPG Pathshala, electronic postgraduate curriculum or course, or the course material, we realized that this is very important for a country like India, that because in India most of the front runner institutions are the public institutions, therefore the state has a huge responsibility to cater to all kinds of students. Now access becomes a very important. I'll just finish. I think my time will be over in next 2-3 minutes. One can just point it out to me so that I can stop. So I realized that lots of students who are sitting on the other corner of the country, they are not able to access the quality material which may be available in best of the law schools. So government was of the view that why can't we sort of facilitate the access of these off-located students to the quality material, video lectures and all that. So we have started working on this, and we prepared almost 1,000 e-text and 1,000 video lectures, where more than 250 top lecturers have delivered those lectures, and this became very, very popular. And I am aware that I have traveled abroad many countries. There the MOOCs courses and online courses are very costly. But I think one may be surprised to note that in India we have provided this completely free of cost. And the MOOCs that we have started, massive open online solutions, open online courses. So in 13-14 courses when we have offered in the field of law, we realized that in our courses, the students who are registering to these courses, the number you can imagine 25,000. And they are realizing that so now the location of law school is not important. And I think in a country like India, which is the biggest democracy, we have to matter that location should not be a disadvantage. So accessing the legal education should not be a problem. Now the point is, if the law schools are the public institutions and the best resources are located in these law schools, we need to create bridges which can be used by the students who are off located to access this quality material. Now it is happening, but I am quite sure that we have a long way to go in terms of creating more and more digitalization of education. Now, last thing which I realized, and some experiment that we have done in the National Law School and the National Law University, Delhi. So since I am little interested in technology, and I realized that there are many software which the parallel social scientists are using in their research, they can be put to use in legal research that we are doing in law school. And we have brought several such AI based and other kinds of software, and we started giving training about those software to our students. To my surprise, they have been picked up very well by the student. And now the case law search, now the judgment analysis, textual analysis, quantitative techniques, these things are being taken care of by the student very well by utilizing the software. I think the last leg of my presentation is just to share very briefly about the recent initiatives that MHRD has done, but they have not been utilized. So underutilization is something very important. Apart from MOOCs, the MHRD has initiated several such platforms like Shodh Ganga, Shodh Sindhu, Vidwan, Swam. These are very important platforms which were propagated by the Ministry of Home Affairs, Ministry of HRD. I have one, still this question is sort of largely remain unanswered to me personally, that despite the availability of all these portals and avenue, there is a significant unutilization of the existing techno resources in India. I'm sure that LegitiQuest is doing a wonderful job. I have used their platform. I discussed with Karan other day that in many places the teachers are probably not aware that any such solution is available, which have a potential to give answer to several of your queries uh, in a variety of ways. Anyway, this discussion is very long. So I always feel when times are challenging, you cannot prepare very well. The best preparations can be done when you are at rest. When we were at rest, we have not prepared. Therefore, we are struggling. This is my the bottom line of my presentation. But I can see, as I derive again from Richard Susskind, who has predicted the future of legal education. If you want to understand the future of legal education, any corner of the world, you please read Richard Susskind, and you will get the answer how the technology is going to disrupt the sustainable and existing practices and would bring lots of changes in the realm of legal education and teaching. So thank you. With this, I close. Thank you for this opportunity. If there would be any question, I would be ready to sort of respond as far as possible.
Sir, good afternoon. Dr. Alok this side. Sir, you have been muted.
Anushka, you are on mute.
Thank you, Alok. Thank you for joining.
Anushka, you're muted.
All right. Thank you so much, sir, for enlightening us. I would request all the participants once again, really apologize for the same, but to mute till the speakers complete their discussion, and we'll definitely love to have an interaction once our esteemed guests are done. Having said this, I once again thank Professor Bajpai for enlightening us with his knowledge. Indeed, today the cultural lag and the mindset which is not being able to change are issues that we are facing, and in order to adapt to the current situation, these are must to change. And also enlightening us about the works of Richard Eric Susskind. We would definitely like to collaborate with workshops, as Professor just mentioned, on these lines as well, and touching about various issues which legal education are facing in today's time, and how can the situation and the institutions and students cope with the same, and much more. With this, I would like to hand over the same to Mr. Peil now. Once again, Mr. Peil, it's an honor to have you here and meeting you virtually after having an opportunity to meet you at the White and Case International Rounds in America. We're honored, Mr. Peil. I hand it to you now.
Thank you so much, Anushka. I'd like to begin by thanking our hosts from LegitQuest, Mr. Khan, Mr. Roy, of course, our able host, Anushka. And also I'd like to very earnestly thank Professor Bajpai for his fascinating presentation. I filled up an entire page of notes, which is always a great sign on these panels. One thing that Dr. Bajpai said that resonated with both Anushka and me is this notion of the cultural lag. Like you, I am a huge of Susskind, and but Susskind is coming rather late to the game from my perspective. You see, I had the good fortune at Cornell University more than 25 years ago to sit in on what was at that time the very first online law course in the world, taught by one of Susskind's mentors, Professor Peter Martin at Cornell, who co-founded the Legal Information Institute, which is the inspiration for a large number of these online legal resources, online, massive libraries and whatnot. Through the Legal Information Institute and through his publications, starting in 1987, Professor Martin was and remains one of the true pioneers in both online provision of legal information and online legal education, legal information and legal education. I share with you your enthusiasm for bringing in Susskind into this forum, or at least bringing Susskind's thoughts into this forum, and I commend the writings of both Professor Martin and Professor Susskind to everybody here in attendance. With that said, I'd like to focus on the fourth of Dr. Bajpai's topics, curriculum and pedagogy. Now, I'll share my screen. We've all, as I was saying before, we've all become Zoom experts over the last 3 months. The whole world are now Zoom experts. In February, March, and April of this year, all over the world, colleges and universities, as we know, flipped a switch. They closed their campuses, sent all the students home, and told the professors, "You're teaching online now." And with that, like magic, we were all expected to just go online. Teachers were suddenly expected to be online teachers, and students were expected to suddenly be online students. Now, the good news is, as law professors, as you all know, we're pretty egotistical. And so when the registrar calls and says, teach online, we say, okay, no problem. After all, teaching online can't be that different than teaching in person. Well, as Dr. Bajpai and other pioneers here in South Asia know, that's completely wrong. And as teachers and students all over the world have found out in the last 3 months, it's not simply a matter of scanning and uploading your readings or recording our lectures or even calling on students to stand and deliver at their seats over a Zoom conference call. The new medium calls for a fundamental rethinking of how we teach and how we learn in the law school context. It's probably, certainly from my perspective, a long overdue and welcome rethinking anyway, but COVID has forced it upon us and has even forced it upon the most conservative of us. I'm not sure I have all the answers here today. In fact, I'm sure I don't, but I'd like to at least get that conversation started. And let's see where we I think I'm back. Am I back? Good. Anushka, can you hear me?
Absolutely, you're audible and you're back, absolutely.
Perfect. So we can talk about legal education as passing through 3 phases. Some of us haven't even gotten past phase 1. We could refer to phase 1 as the sage on the stage. This is how many of us of a certain age might have been taught. It's a European approach to legal education. This is where the dusty old lecturer with his stack of dusty yellow notes stands in front of a classroom and delivers that lecture. And it might be the same lecture that he was given by his teacher and his teacher was given by his teacher. The class meets for 60 or 90 minutes or 2 hours, 1 or 2 or 3 times a week. The instructor reads from those notes. And by the way, it was almost always a man. The students dutifully write down every pearl of wisdom that falls from his lips. And their out-of-class reading is probably the primary sources, the Contracts Act itself, the Arbitration Act, or at most, selections from the 27th edition of a dusty old horn book that sets out and explains the relevant case law and the doctrine. And at the end of the semester, the students sit for an exam, which simply expects them to regurgitate the law. What does Section 117 of the Advocates Act state? What is the definition of aggravated battery? In short, what does the law say? Now, phase 2 is just as dusty. Famously introduced in the 1870s by the revered Dean Christopher Columbus Langdell at Harvard Law School, the Socratic method involves the instructor asking a series of pointed questions, a terrified student answering those questions, and over the course of that discussion, the entire class learning something, not just about the law itself, but about the reasoning behind the law, about the gaps and flaws behind a black letter reading of the law. Over the past 150 years, and that's how old this is in the law school context, the Socratic method has been improved, modified, distorted, and diluted in so many different ways that it's hard to even find a Socratic teacher anymore. Many law schools claim to use the Socratic method, but in truth, what most of us do is a modified case method or a question and answer method, what we might call soft Socratic. But the common characteristics of all of these phase 2 classrooms, mine included, is that learning is a cooperative endeavor between the professor and the students. The students read the case outside of class, they read the law, they read the doctrine, they come into class, and our time inside the classroom is spent testing their understanding through questioning, but also demonstrating, often through edge case hypotheticals, the limits of the law and the reasoning behind the law. Now, phase 3 is what many of us would consider to be cutting edge. This is the so-called flipped classroom, or as Professor Allison King called it, the guide on the side, in contrast to the sage on the stage. Now, this isn't as new as we lawyers would like to think. The flipped classroom dates back at least to the late 1980s and has been made famous around the world by Salman Khan and the Khan Academy, which, as it's hard to believe, has been around for almost 20 years now. In its various forms, the flipped classroom is a student-centered classroom. If there are readings or lectures, those are done as homework. The time we spend in class is spent on student group activities, on student presentations, all of which focus on higher order thinking skills at the top end of Bloom's taxonomy. So we're looking at problem finding rather than problem solving, knowledge creation rather than knowledge consumption or memorization. In a flipped classroom, the instructor may speak to the class little, if at all. Now, in point of fact, most of us use a little bit of all three of these phases. Sometimes we're lecturers, sometimes we are inquisitors or facilitators, and sometimes we're spectators and guides. But the challenge is that none of these phases are suitable for the situation in which we currently find ourselves. Let's take as a given the following, which you might consider the worst case scenario, but here in South Asia, it's the scenario. So the professor is now sitting at home in front of his or her laptop without her library and without her blackboard, her whiteboard, or without the four walls of a classroom. Each student is also sitting at home in front of his or her laptop, or mobile phone even, without access to the high-speed campus internet, without access to the library, and without access to his or her classmates. And most importantly, this student, since she's at home, has all of the usual home distractions: the dog who needs walking, the grandmother who needs visiting, the kids have to go to the doctor, which means unlike face-to-face teaching, we don't have a captive audience. Every model we've come up with so far, all three of our phases, in some sense depend upon a captive audience. Even if we don't have them physically trapped in a classroom, we do have them programmatically trapped as full-time or part-time students. In short, in their minds, they're committed to learn every day from 8 a.m. to 5 p.m. or for whatever they consider to be the school day. This altered landscape, as our hosts at LegitQuest have called it, poses a serious challenge to all three models of legal instruction. With respect to the sage on the stage, the dusty old professor lecturing from yellowed notes, for him, it's just hard to stare, as I'm doing right now, at an unblinking eye of a camera for 60 or 90 or 120 minutes. There's no audience. But more importantly, from the student's perspective, we Okay, good. But more importantly, from the student's perspective, we know that there's only so long a student can sit in front of a lecture on a computer or a phone screen. Psychologically and physiologically, the medical experts tell us the longest we can reasonably expect an undergraduate student at that age to focus on a lecture, the longest attention span we can count on for a lecture is 15 to 20 minutes. Now, it's an open question what their attention span is in the classroom, but we've always sort of assumed that we can at least hold their attention for an hour. Now, with respect to the Socratic classroom, we have different challenges. Sure, I can have a gallery of students like we have at this meeting, and I can even get them to raise their hands, unmute. I can call on one, she can unmute her microphone, I can ask her questions, she can answer the questions, she can remute her microphone, and then I can call on somebody else. And worst case scenario, what did you say, professor? I'm sorry, what did you say, student? I'm sorry, what did you say, professor? But even assuming that works, even assuming the network holds and the bandwidth is sufficient and all these other things, we lose the major strength of the Socratic method when we go online, and that is the simultaneity of it all. When I have a student in my physical classroom, and she and I are going through a case or a reading together, question by question, step by step, the journey is as important as the destination. The mistakes and missteps that she makes attempting to apply the rule to the scenario or attempting to abstract the rule to the general case are as important to her, to me, and to the class as getting the right answer. Now, on the other hand, once we go online, when the student is sitting comfortably at her desk at home with one window open to my classroom, as you all have, with a second window open to the case we're reading, a third window open to his or her notes on that case, a fourth window open to the definitive interpretation of that case from Langdell or Hart or whoever, not to mention the Wikipedia and Google resources that she may be tapping away at in the background, it becomes less of a Socratic dialogue where we're both existing in real time and mindful of the conversation, and more of a race to see if the student can find the answers and recite the answers to the questions I'm asking. And that's just not why we do the Socratic method. And finally, the flipped classroom, our modern phase 3. This is our student-centered model, and when you put it that way, it sounds like this should be the strongest of the 3 models. And this is certainly what a lot of the MOOCs, the MOOCs out there are assuming. After all, the student does all of the primary reading and basic knowledge acquisition on her own terms and in her own time. But the problem is the theoretical basis for the flipped classroom assumes that there is something to flip into when you're done with that. That's why it's called a flipped classroom. It presupposes the existence of a classroom. There needs to be a venue for the collaboration with other students, for the guided learning with the professor, for knowledge creation. There needs to be a venue for group work and for the higher level skill building and practice. And that's already a challenge inside the traditional classroom. Imagine doing it with Zoom rooms. Imagine jumping in and out of small groups, small breakout sessions, reconvening, re-breaking out, all of the things that we like to do in the flipped classroom in the online environment, all the while keeping one eye on the learning outcomes and a second eye on the clock. Now, none of these 3 are impossible, of course. I'm just saying they are suboptimal, and I am suggesting humbly that trying to force them into this new medium creates frustrating, unnecessary, and often counterproductive work for both the student and the instructor. So what is phase 4? I'm sorry to say I don't know yet, but we're all finding out. I do have some ideas as to what phase 4 should encompass. The first is to give up entirely on teaching students what the law is. And I know that my colleagues at the Jigme Council here in Bhutan and your colleagues at the Bar Council of India will shudder at this because a lot of the accreditation bases and the curriculum development is designed on the assumption that we are in some sense delivering knowledge. What is the law? But no, good law students and good lawyers should find that out on their own. Rather, we should focus on how to find the law and how to find out what the law is and what to do with it once you find it. And I mean this quite literally. One of the first things we should be teaching our students in this new environment is where the statutes, where the cases, and where the doctrine lives on the web. We should be giving them URLs. And how to find that stuff if it's not already located in one place through the good work of people like Dr. Bajpai and his people. And once we get beyond the primary law, we have to give them the skills to evaluate the currency and the validity of the doctrine. Is this commentator more authoritative or more persuasive than this one, and why or why not? The second thing is to give up on ever bringing together all these law students in one place at one time. And I don't just mean physically, I mean even virtually. I'm calling for nothing less than the death of the 9 a.m. to 10 a.m. large session contracts lecture with 100 students sitting in a room or a Zoom room, all together staring as the teacher performs, or staring as the teacher and a student perform Socratically. If I'm a dusty old lecturer, then there's no value, there's no point other than my ego, which I accept, in just asking the students to show up at 9 a.m. on Mondays, Wednesdays, and Fridays to watch me perform live for an hour every morning. If the content is that important, then just upload it. I can either scan and upload my dusty old notes and let the students read it themselves, or I can turn it into a PowerPoint or a voiceover PowerPoint or any number of other things and let the students consume that source in their own time. And who knows, the students are creative. If I end up doing a video PowerPoint or something else, well, if there's real performative value, if there's value in watching me deliver the lecture, then upload, pre-record it and upload the video and let the students watch it. And as I was just saying, it is likely that the students will then get together on Facebook or on Zoom themselves or whatever and start a watch party where they can sit down, press pause on my lecture, ask each other questions, and really interact with my lectures in ways that a dusty old lecturer inside the four walls of a traditional classroom, the students aren't comfortable doing, and I'm not sure that that lecturer would allow them. In an online world, the Socratic teacher isn't that much different than the sage on the stage. Except now it's two of us performing. As I said, it's me and a student performing for the enjoyment of 100 other students. Again, there's just no point in forcing everyone to wake up at the same time and sit through that. It might be instructive to the individual student who's on call, and it might be gratifying to me to see that the student is getting it. But in that case, why not discard the sort of group presentation and instead engage in smaller one-on-one meetings with individual students or guided conversations with small groups. I'd be happy to touch on more of these during the Q&A if anybody's interested, but I think the principles that we need to explore as we're looking at the way forward are fivefold. The first is self-guided learning. We give the students the skills they need rather than giving them the law, and then let them find their own way. And so this is a replacement of sort of the first year fresher introduction to law. Second of all, rather than teacher-generated content or legislator-generated content or court-driven content, focus on student-generated content. Independent writing, independent research, student responses to questions instead of in a Socratic dialogue in the class with a pre-recorded video. They all know how to use WhatsApp. They all know how to record themselves. They're learning how to do voiceover PowerPoint presentations. And so we replace this idea of that we have the content and we are imparting it to the students, and instead, having taught them the skills, they generate the content. Third of all, rather than interacting with all of the students at once in a 9 a.m. to 10 a.m. Contracts hour, the instructors should be interacting one-on-one or with small groups of students throughout the week, throughout the semester. And so there is no one-size-fits-all approach to the class. Fourth, we abolished the class meeting entirely from the instructor's point of view, and the class is no longer a metered regular event. It is now smeared across the entire semester with different students dropping in, dropping out, engaging with the professor as their activities and as their skills are called into play. And finally, and this is the one that will make the accreditation authorities, be it the American Bar Association or the Bar Council of India or anyone else, shudder, and that is that our learning outcomes need to focus on imparting skills and acquiring skills from the student's perspective, rather than memorization of knowledge or, to the next level, application of that knowledge. Going forward, our biggest challenge, I'm pleased to say, is going to be training the teachers, as Dr. Bajpai has also noted. This is new for all of us. It's not how I've ever taught before, and it's not how I was taught when I was a law student. The good news is the students are already there. This is how they've been interacting with the world. You know, our freshers this year were born in 2002 or even 2003. This is how they've been interacting with the world since their generation was born. Even if their primary and secondary school teachers have never thought of it this way or never thought to teach them that way, they will be receptive if we confront the world of legal knowledge in the same way that they've been confronting everything from cricket scores to football scores to politics to fake news to everything else. If we build it, as the movie says, they will come. I look forward to your questions, and I once again thank LegitQuest. I thank Dr. Bajpai, and I thank everyone in the audience for letting me brainstorm a bit in real time. Thanks so much.
Thank you, Mr. Peil, for enlightening us with your knowledge and for the wonderful presentation. By wonderfully displaying about the world we live in and enlightening us about different teaching models and their associated problems. And also challenges for academicians on wherein they have to overcome the problem of sitting in front of the camera with in front of a unblinking camera for hours, and how and what challenges the student face while focusing on an online lecture and the way ahead. Thank you once again, and we are honored that our esteemed panelists could take out their precious time. And also, I thank all the participants who had joined us and who have also joined us in the course of our legit class and have spared their valuable time with us. I hope everybody is taking care and are safe and sound. We may now proceed to take few questions which we have received from our participants, and the same could be taken up by Professor Bajpai and Mr. Peil, or in any manner which our panelists would find it comfortable to take questions or add on to it if required. I request if everybody could mute their devices. And we may start with the first question, which is mushrooming of virtual activities nowadays causing a physiological pressure among learners? Is one of the questions that have been put to us. And maybe Professor Bajpai could take lead on this question.
That concern I have recently noticed in one of the writings, and that is fact. But the point is more relevant in a school setting, because the school children are being exposed to longer hours of exposure to the screen. But as far as the young adults are concerned in law school, I think even if they are not on online courses, they are on a smartphone or they are computer otherwise. I think they have really adopted this technology very well. But there are side effects of every technology, I would say. But the time can be minimized. You can, I think, cut down your unproductive activities by deploying yourself more and more on the productive things. So you have to prioritize your activity. That is my answer.
Wonderful. Mr. Peil, any takes on this question about these days, about the mushrooming of virtual activities nowadays causing physiological pressure amongst learners?
Yeah, so I speak here both as a law professor and a university professor here in Bhutan, but also as the father of a 12-year-old and a 7-year-old whose schools are also closed and who have been doing Zoom learning for the last 12 weeks. I would say the students of our undergrad generation and younger, like my children, don't suffer physiologically from mushrooming of online activities like online teaching. They suffer physiologically from the mushrooming of poorly implemented online and virtual activities. It is the stories from around the world, not just here in Asia, but the stories of the parents freaking out and the students freaking out because they're going to one Zoom meeting after another, where the teacher tries gamely to simply transfer the lecture or the group work or whatever one-to-one from the real to the virtual environment. That's where the physiological pressure is coming from. I mean, here in Bhutan, we shut the law school down for a solid month before we resumed online learning, so that we could watch the other universities and law schools around the world and here in Bhutan. And so a lot of the things I'm saying about time, about attention span and about working with how students think is based upon the experience, sometimes successful, but most of the time not, of other universities and colleges in Bhutan, in India, and around the world, as they attempted to get to pour old wine into new bottles in many cases. And so one of the things that we have done here at JSW is we simply shut things down and then forced all of our instructors, no matter what level of seniority, to go through training on how to redesign your pedagogy and redesign your curriculum for the online environment. And we started from the presumption that everything was going to change. So I'm not as worried about this, provided that we can figure out on the instructor side how to teach. I think the stress and the physiological complaints are coming from the fact that we're so far not that good at it. And so it's our problem, not the students.
Thank you so much. I think the next question is an interesting question for our audience as well, which is, what can be the effective teaching strategies to ensure students' engagement in an online law classroom? So anyone, Mr. Bajpai or Mr. Peil could go forward with it. I think Mr. Peil could go forward with the same first.
Sure, I'll take a stab at this first. And this is the million-dollar question, right? And this is the entire fourth of Dr. Bajpai's 9 elements. And as he says, one of the ones that's gotten the least treatment, and the least discussion. So number one, smaller groups, much smaller groups. It is impossible to teach 200 students online. It is impossible to teach 100 students online. I mean, I'm putting forth the radical proposition that we're talking probably no more than 10 students. Second of all, constant interaction. And so we're not just talking what I'm most comfortable with, which is Socratic style interaction. You're talking about students giving lengthy reasoned answers, multiple vectors. So it's not just professor to student. It is student to student learning. It is student generated content. And as I said before, asynchronous learning. So using pre-recorded lectures, letting the students generate their own content in their own time. We may be seeing, in my mind, we may be seeing the emergence of the only time you see your professor alive and in real time is during office hours, because everything else is sort of smeared across the entire day. Off the top of my head, that is what we should be thinking about. Smaller classrooms, distributed times, distributed meetings, and smaller synchronous and asynchronous groups. Dr. Bajpai.
Professor Bajpai, if any leads on this question about effective teaching strategies to ensure students' engagement in an online classroom, specifically online law classroom.
I couldn't hear actually. There was some.
Am I audible, sir? Am I audible?
Yes.
Wonderful. So any further leads on the question, what could be the effective teaching strategies to ensure students' engagement in an online law classroom?
May
I? Professor Bajpai, can you hear me?
Yeah, so should I?
Absolutely, absolutely.
Actually, taking clue from what Michael said, I am also a firm believer that if you are effective in offline teaching, you can be effective on online teaching too. You need little adoption in certain sense. I think we have not yet reached to that stage of mastering the pedagogy in online teaching is little different from pedagogy in offline. That is number one. We need to understand, as Michael was rightly pointing out, are you in a position to gain the attention of the student even while being online? What can you do for that? I have a very quick, this is from my experience. So I would ensure that the participation of the student is far more important in online classes. And if you are able to engage them, when I use the word engage, I mean to say you need to bring some prior preparation. Before going to online classes, I think you need to do some prior preparation. Prior preparation means you should have sent some assignment to the student to be able to understand them that they would require at a time to give little interaction and reaction. I call it reactions, mapping of reaction. So I would essentially appoint the student to give some reaction after a certain interval. So when they are ready to give reaction, so their mindset is always agile and active all the time, because there is a tendency of getting inactive while being online if you are not speaking and if you are simply listening. This is the problem. Whereas in offline classes, you are able to sort of create some kind of activity throughout your lecture. So in online also, you have to sustain that kind of participation by way of assigning them some opportunity to speak, because professors have a habit of speaking and speaking without really bothering that to what extent the professor is being registered by the student. So I think if we divide, a smaller group is a very important point that Michael was saying. So if you have a smaller group and you have already assigned certain things to them, that after a certain interval, the professor must teach the student to have their reaction on what was said. And the teaching should be not a monolithic kind of teaching. It should be compartmentalized and segmented teaching. When I say segmented, you divide your lecture in 6-7 parts. And for each part, you appoint what I call, in my classes, I call them interactors. So interactors are identified beforehand, and the interactors will have to speak. There is no choice. So interactors would be ready, and other group will also react. So that you can create an atmosphere, even on online classes, that can be very rewarding. I'm telling you, that can be fantastic in the end. But I am again and again saying, some pedagogical preparation need to go in before you get on to online classes delivery. It cannot be simply TV news reading kind of approach.
Thank you, sirs, for these wonderful insights. The next question is from one of our participants here, which I will read. Why is it that the most undergraduate law students feel that to learn criminal laws are easy, but civil laws are difficult? I request Professor Bajpai maybe could put some insight.
I am little prejudiced to criminal law, but I would answer this. I think it is not criminal law. I have seen many, with due respect to everybody, I have seen criminal law getting murdered every day by many teachers. Even you can murder the class of criminal law very well, and there will not evoke, you will not evoke any attention even to criminal law classes. Criminal law is considered to be a very exciting topic, but you can kill this lecture, you can kill this subject very easily by virtue of your lecture. So I think we should be ready. Even I am aware that I have heard Mark Galenter, I think on civil issues, he was speaking on tort or something. I find him immensely effective because he had that capacity of engaging and making that lecture interesting. I think the question that he is asking, it is of pedagogy basically. And pedagogy is highly teacher-centric. Even if you know the methods of teaching, but some element of the personhood of the teacher will go. And that personhood is ultimately the thing, I think. And some teachers have that kind of aura or that kind of X factor, I would say, that they are able to attract the audience.
Thank you, sir, for this question. Mr. Michael, would you like to?
Sure. I have the opposite bias. When I practiced law, I was a transactional lawyer. When I was a law student, I had zero interest in criminal law, and my watchword throughout my practicing and my academic career has always been, if I or my client sees the inside of a courtroom, somebody's done something horribly wrong. My favorite courses in law school were the civil procedure courses. In fact, I took electives in civil procedure and so on and so forth. I think the problem here is with society, as it always is. First of all, criminal law is what most of us, before we go to law school, assume the law is. And if we ask first-year law students or grade 12 students to write down, even the thoughtful ones, to write down what the law is, most of their answers are going to focus on some sort of way that the state enjoys a monopoly of violence or a monopoly of punishment to enforce compulsory rules. I'm a law and society type. For me, law is all of the folkways and more or less binding norms, guidelines, from whatever source, not necessarily from the state. It could be from the church, it could be from social leaders, it could be from parents, it could be from generation to generation. But that's not what most of us think of when we are undergraduate law students. And for many of us, that switch doesn't flip until our third or fourth year in law school. And that's when the great civil lawyers and the great transactional lawyers are born, is in that fourth and fifth year of law school where something flips and they say, wait a second, I get this. Law is about a lot more than I thought. The second thing, I agree with Dr. Bajpai that A lot of it is teacher by teacher. I mean, let's face it, and I don't mean this in a rude way, but criminal law is sexy. You know, there's people murdered. There's exciting things happen. There's chases. And in the end, the bad guy goes to jail for a long time, and the court gets to issue judgments that are self-righteous and about protecting society. And, you know, we get into the theories of criminal punishment and whatnot. That's exciting. And it takes, I'm not talking about myself here, it takes a special kind of professor to give that kind of passion and excitement to a course in appellate procedure, to a course in corporate law. Those just aren't naturally sexy. But as Dr. Bajpai points out, those professors do exist. And I think one of the exciting opportunities now that we're going online and geography doesn't matter as much, we can start beating the bushes for professors that, you know, a year ago would never think of themselves as professors because they've got a job or because they live a long way away from the law school. And we can find those passionate instructors. So this is both a challenge and an opportunity.
Wonderful, thank you. So the next question is also a little bit more like it's very interesting, and I'm sure it will help our participants here today. The question is, what skills should a future law trainee must have now? And are specialized webinars good for enrichment of one's CV? So I think Mr. Michael could enlighten our participants with this.
That second one, that question took a hard left turn all of a sudden. Are webinars good for enrichment of the CV? Is that the question? I thought we were going to talk about are they good for enrichment generally, but we're specifically talking about resume padding here. I'm not sure yet. The problem is that webinars in the realm of continuing legal education and with things like MOOCs and Coursera and these kinds of things, the online webinar doesn't yet have the prestige that that a face-to-face conference or this kind of thing has. Now that being said, we're adjusting fast, and you know I've already got 5 conferences over the next 6 months that have been that are prestigious, good conferences that had they happened physically would have been for a student or a faculty or anything good resume lines. The only difference is now they're not going to happen face-to-face, they're going to be virtual. And so talk to me again in a year, because I have a feeling we're going to be blurring that distinction. But at the moment, the answer is, you know, an employer or a potential employer will look at that and say, well, those aren't real conferences. You were just one guy in a gallery of 1,000 people watching people talk. You probably didn't even put any pants on. You were probably in your pajamas.
And what about specialized webinars? Do they have any effect on CVs if today's law students or academicians attend the same?
My gut feeling right now, if you're talking about applying for a job or applying to a graduate program, or you know, as of today, the answer is probably no, or at least not as much as they should be. Before I turn to the other question, I'd like Dr. Bajpai's comments on that one, because that was 2 questions hiding as one. So.
Professor Bajpai, am I audible?
Yes, yes.
Wonderful. So the question directed to us is that are specialized webinars good for enrichment of one CV? So this is one of the 2 questions.
Actually, I have a different take on it. I do not mind webinar as a medium of communication, as long as it enriches a particular objective. I like the term used, specialized webinar. I think the idea of a specialized webinar is that much more focused and probably geared to a particular specialized theme. And as long as that is happening, and if they are organized in a very particular manner where the issues, themes, and other aspects are clearly identified, including the audience and the speakers, I think insofar as they are able to communicate and enrich the requirement of the audience or the students or the researchers, there is no harm. Offline or online is simply a matter of spaces. So I am not talking, and as I am saying again, quoting research, these things are bound to arrive, not because of pandemic. Unfortunately, the association being drawn that these things are happening because pandemic is there. I am foreseeing a scene where these things will become a new normal, what is called. Now, new normal means even when you will have no, you will see the change when the things will return to normalcy. Lot of people would want that they are fine with an online webinar rather than traveling to sort of 4 or 5 hours to a destination, spend a night or two and come back and lose a lot of time. So I think if we develop some kind of experience and more organized and systematic way of organizing it and enriching in the same way as we, definitely there is no comparison of the actual and physical thing, but this is very interesting medium, and I think it should be supported and be strengthened. Doesn't matter, in the end it also results in the enriching of CV. If it is enriching the CV, what is the harm? In any case, the people are spending their time, 2 3 hours time, and if they are listening, they are gaining, I don't mind it. And it should not be categorized anything lesser or anything superior. As long as participation is happening, presentations are happening, people are gaining, and there are demonstrable results of these activities, I think this is perfectly all right.
Wonderful. Thank you, sir. So, Mr. Michael, the next follow-up question in this one was, what skills do you think a future law trainee must have now?
And so I want to build on, in answering this question, I want to build on Professor Bajpai's comments, which I endorse 100%. You know, I'm talking about the right now, but I do think that we're moving very quickly in the direction he's talking about. The number one skill that a law trainee must develop right now, and it sounds easier than it is a constant hunger and a constant desire to broaden and deepen your skills, what you in India call your CV, but what I would just say, your own skills as a person, whether that is through constant reading, constant attendance at in-person or virtual specialized webinars, finding mentors and finding peers that you can talk with, argue with, bounce ideas off of, constant writing. And I know most of us who aren't in academia, although this is also changing, don't see ourselves as writers or as content developers or knowledge generators. You should, and you should be doing that now as a trainee. And so all the other stuff, yeah, get practice writing, get practice researching, get practice talking, but those come if you follow that first step. You have to be constantly hungry for more knowledge in this learned profession from the moment you wake up to the moment you go to bed at night. And if you're really good at it, even overnight, you're dreaming the law. You're thinking of what the next book you're going to read is, or the next blog post you're going to write, or the next article you're going to write. So that's my number one, and I'm not sure there is a number two. There's lots of other skills that I would also recommend depending on what flavor of lawyer you want to become, but that one is number one, as we say, with a bullet.
Wonderful. Thank you so much, Mr. Peil. The next question that we would like to take, and I would like to divert this to Professor Bajpai. So the question is, while looking at the current scenario, will it be right to allow law courses, specifically LLB and LLM, in digital mode in India? What do you have to say on this?
See, the law courses in digital mode, if the idea is that the complete shift from physical classes to digital mode, I think that may not be fully possible. Because the structure of full-time LLB course is based, where a lot of clinical work, lot of field-based exercises and other things are involved. I would say we should not think always in extreme terms. I think the courses can be supplemented by online inputs by so many experts which are unable to travel to one law school for various reasons. I remember that National Law University Delhi organizes various seminar courses, which are generally delivered by the practitioners, lawyers or judges. We are located in the other corner of the city, and the other part, most of the practitioners live. So at times they find it is difficult to travel and lose their couple of hours. They said, I can deliver through video call. Now, this part is driven by the reason of practicality, and it would be time saving. At the same time, you are delivering. I don't think of a complete shift of LLB courses into online mode at this moment. But yes, I can of course see a huge possibility of being, these courses being delivered partially by the experts through online medium. You can involve the experts from overseas because they can't travel. So I think a mixed method is the safe way to sort of move ahead with these courses. Campuses are beautiful. To experience the campus, nothing can beat actually. I always say to experience the campus is the ultimate thing. Our students are actually dying to come back to the campus. They are not here for the last 2 months. They are writing me when we will be back. Because experiencing the campus and physical world, there cannot be any alternative.
Thank you so much, Professor Bajpai. Seeing the time, it's 5:20 now, and very kind of our distinguished speakers to even be so patient with us post 20 minutes because we were supposed to wrap up around 5 p.m. Nonetheless, just a very small question, a very general question, which I'd just like to put up to our panelists. Is some sort of recommendation on books or reading materials that you would like to advise our participants? And thereafter, we can end up our session, of course, with a vote of thanks by Mr. Karan. Professor Bajpai, if you could enlighten participants with any sort of recommendations on books or reading materials that you would like to.
I think I have already recommended research Susskind books on this subject. I think the future, the future of the profession and end of lawyers. These two books are very important, which every law person should read. And another thing which I would recommend, and which is freely available, and I have already spoken about that. We have created a huge resource. Many people may not be knowing. EPG pathshala resource is available in 18 subjects of law. So these subjects are very common to both PG and UG. And if you see these courses, so there are 3 components of these courses and they are freely available. You can just click on the computer and download the entire thing, or you can. So the first part of this material is the e-text. So suppose somebody wants to understand the geographical indications, the first year student want to understand some concept of corporate law or criminal. So these courses have been designed in a manner to deliver the basics of the law. That is the e-text part. And also there is a video lecture. And the video lecture is very comprehensive, very edited one, very well created. So EPG parts, and there are certain exercises. So I think I would recommend the young student especially to go for the EPG. You can search EPG Pathshala Law and you will get the linkages. And there would be a list of 18 subjects of law. You can click and you can see, and lots of things are before you. So I would recommend that you can see those.
Thank you, Professor Bajpai. Mr. Michael, any recommendations for the participants today?
Sure. On the topic that we're discussing today, I also endorse reading as much Susskind as you can lay hands on. And I recommend going through his bibliography. You'll see my mentor, Peter Martin, on that list. You'll see all kinds of other things. And once you get into that universe and the whole Society of Computer and the Law, the SCL crowd, it's bottomless. But as far as pedagogy generally, so the topic of my thing, I would recommend in particular the writings both online and offline that are published in the Association of American Law Schools Journal of Legal Education.
Yes.
They've been giving thought to things like the classroom without walls for years. And that's really, at the end of the day, what we're talking about here is how do we deal with what we as humans feel to be an imperfect medium in many respects. It's hard for me not to shake your hand. It's hard for me not to sit next to Dr. Bajpai on this panel or probably across from Dr. Bajpai while Anushka sits between us and moderates. That's difficult for us to adjust to. Well, they've been working with that question for a long time. And so the Journal of Legal Education's articles and archives are available freely online, and many people for many decades have been tackling these issues.
Thank you so much, Mr. Peil. It was wonderful. Mr. Bajpai, I think you have something to add there.
One more journal I would recommend. It is from Cornell only, and my friend Ted is the pioneering in empirical legal research. So JELS, Journal of Empirical Legal Studies, if somebody at the advanced level would like to see the state of empirical research especially. So Ted is the father of empirical legal research, and we great associate. We have been working together at NLU Delhi for some years before his untimely demise. So Journal of Empirical Legal Studies, your colleges must subscribe. We are subscribing this, so I'm extremely satisfied to see the quality of this world-class and probably the #1 journal in the field of legal research.
Thank you, Professor Bajpai. And once again, thank you so much for sparing your valuable time. I know we've already run out time, and I'll just request Mr. Karan to finally bid farewell to our distinguished panelists today.
And I'll just point out that Ted Eisenberg was another of my professors at Cornell back in the day.
Right. He's a good friend, actually. I invited him a couple of times for organizing empirical legal research workshop at NLU Delhi. 3-4 workshops we have done together, and we developed a huge, great friendship with his entire family, and so it's a wonderful association that I have had with him.
I agree.
Yes.
Great. Thank you so much, Dr. Bajpai and Mr. Peil, for this wonderful, informative, and insightful session. Our participants loved it. They are still writing to us, all of them. And we have, thank you for being so patient. And because it was a 1-hour session, it went a little longer. But trust me, we still have so many questions to be answered. There are at least 15 to 20 questions. But of course, I've asked all the participants to write it to us, so we can maybe write it to you and get a answer from you. Thank you again for this wonderful time. And with this video recording will be on the LegitQuest YouTube channel tomorrow. And anyone who has missed can go and take a look at the video. And a wonderful session, a lot of books, and we have already discussed with Dr. Bajpai the Cornell Empirical Journal also. And Mr. Peil, I'm a huge fan of Peter W. Martin as well. I follow all of them because I studied at UPenn. I did my master's there. So again, thank you for your time. Pleasure seeing you here, sir. And thank you for all the participants, and wonderfully moderated
Anushka. Thank you for your time. Thank you, Karan, for the opportunity. Thank you, everybody, once again. And I wish everybody stays safe and takes care of themselves. And thank you,
sir. Pleasure.